You're driving home after dinner. You see flashing lights in your rearview mirror. Your stomach drops. An officer is now walking up to your window and asks, "Have you been drinking?" Then he says, "Step out of the car." And a few minutes later comes a question that can change everything. Will you take a breath test? And in that moment, your brain starts racing. Right? Do I have to? If I refuse, will I go to jail? If I agree, am I handing them evidence? The problem is obvious. You're being arrested for a DWI, but you feel panic. You don't want to make the wrong decision. And the deeper problem is fairness. You want to know what your rights are under Texas law. Okay, so tonight I'm going to explain exactly what Texas law says, what happens if you say yes, what happens if you say no, and the one detail that surprises almost every client who I end up dealing with when dealing with a DWI. And I want you to stay with me, okay? Who am I? I am Ruben Restrepo. I am a Texas criminal defense attorney. I've handled hundreds of cases related to DWI and gotten hundreds of dismissals. And in the next few minutes, you'll learn whether you legally have to take a breathalyzer, what implied consent means, what happens to your driver's license if you refuse, how prosecutors use your decision in court, and the most important part, the hidden consequence most people don't understand until it's too late. Okay, so let's break this down clearly. Let's go with number one, the first question. Do you have to take the breath test? Well, under Texas law, when you drive on Texas roads, you give what's called implied consent. That means if you're lawfully arrested for DWI, you're considered to have agreed to provide a breath or blood sample. But there's a big caveat to that. You can refuse. And the Supreme Court hasn't actually said that implied consent is a real deal. So there's a little bit more to it than that. But you can refuse and you can say no. However, and it's critical, refusing does not mean nothing happens and then you just get to go home. Okay? Before I go further, make sure you subscribe to the channel. I break down Texas criminal law in plain English so you can protect yourself and your family before the problems happen. Let's talk about what really happens when you refuse. If you refuse a breath test, your license can be automatically suspended. Now, let me talk about that a little bit further. What's a refusal? How do you get to this point? All of the other stuff has happened, right? I've talked about it before, the sobriety test, and the officer has made the decision to arrest you. And then they're going to read you something. It's called the DIC 24. When they read you this document, the first thing it says is you're under arrest. So a lot of people miss that part. So you are under arrest. But then it starts talking about licenses being automatically suspended. And they're going to ask you at the end, will you give a breath test or a blood test? You can consent to either one, or you can refuse both. Okay? The suspension changes. For a first refusal, the suspension can last up to 180 days, right? So let's talk about that as well. If there is a second refusal, not second time, but you already had a license suspension for DWI within 10 years, it can go as high as 2 years. Okay. Now, this is important. The suspension is separate from your criminal case. That means you can beat the DWI and still lose your license if you don't act fast. You have 15 days from the date of arrest to request what's called an ALR hearing, an administrative license revocation hearing. You miss that deadline and the suspension just goes through automatically. That 15-day window is where many people make their first major mistake, missing it. Okay, let's flip it. What if you agree to take the breath test? If your result comes back at 0.080 or higher, the state now has some evidence against you. They call it scientific, but whatever. It sounds final. However, things get a little bit complicated. Kind of like needing an experienced lawyer complicated. Breath machines must be properly calibrated. They must be properly maintained. And officers have strict rules they got to follow. And if they don't, I once represented a client, we'll give him a fake name, Daniel. He thought he was cooperating and would make everything easy. He took the breath test over the legal limit, kind of normal, right? But he was thinking the case was over. But I ended up getting the records. And guess what we've ended up finding? That the machine's calibration history, something was up. And it changed everything. So here's the truth. The decision to blow or refuse is not black and white. It's very strategic. And every situation is different. That's why we have so many lawyers that say it differently. If you refuse, they may take blood. But if you say in consent, then they'll get the breath test. But what did they do? Did they do everything right? Because the officer is the one that's going to take the breath. Or a DWI technician. It's not going to be some hospital person or person who knows how to take out blood. And then the tester is going to be somebody different for blood. It's going to be somebody who deals with a gas chromatograph. Now, there's problems with that, but we'll deal with that in a different video. Okay, so here's the next layer you need to understand. Police cannot physically force you to take a roadside breath test, but they can request a warrant for a blood draw. Now, many Texas counties, judges are available 24 hours a day to approve electronic warrants. Some counties, they're not. But in Harris County, they are. So even if you refuse, you may still end up giving a blood sample, but it's going to be under a warrant. Here's where things get a little bit complicated. If you refuse initially, prosecutors can tell the jury you refuse. They may argue that refusal shows consciousness of guilt. That does not mean you're guilty, okay? But juries, they are still allowed to hear it, and that's going to be brought up. Now, how can that affect things? It affects how people feel about the situation. Okay, so what do? There's no universal answer. I'm a lawyer. It depends. But we can have a framework. And this is what I say. We stay calm, respectful. We don't give any extra information. And we understand that all the choices have consequences. Right? The biggest mistake is not getting the breath test or refusing. Doesn't matter. The biggest mistake is right afterwards. Don't miss that 15-day deadline. Right? You got bond conditions, occupational license options. How is this going to affect your long-term record? Okay. All right. Now let's talk about the next step that saves clients thousands of dollars and months of stress. Calling an experienced DWI defense attorney immediately afterwards. Early action changes outcome. Do you know one? All right. I've seen cases collapse because they didn't move quickly. Right. So what we got to do is we have to work harder because timing matters. Okay, let me bring this home clearly, right? And I want to talk about and touch something that I don't want you guys to miss. There are two types of breathalyzers. One is a portable breathalyzer. The other one is a stationary at the station breathalyzer. The Intoxilyzer 9000 or 5000, that's at the station. That little portable one that you might have, something like this, and you go, no. That's portable. Guess what? Case law says that can't come in because that's not going to be calibrated. The only thing that is used for is to say, well, was this person drinking? It's not very reliable. Sure, you're going to see people, maybe somebody might comment, oh, it is reliable. It definitely shows stuff. What they're going to be saying is very much not analytical, anecdotal. It's very anecdotal because I have an anecdote that was somebody blew twice the legal limit in a portable breathalyzer, but it came basically right at 0.080 when they were at the station, and not enough time had passed for those who kind of know what I'm talking about. What does that mean? That means they were probably blowing too hard. Maybe they had a little alcohol in their system. You don't do the same thing. The only thing it's there for is you drink alcohol. That's it. But sometimes it can still get in the minds of the police officer or the prosecutor. So, going forward, what are we talking about? You can refuse a breathalyzer in Texas. Refusal triggers license consequences. Agreeing gives the state chemical evidence. Right? Refusing does not guarantee they won't get a warrant and get the result anyways. Your power is not just in that moment on the roadside power, right? Your power is in what happens next. Now, if you need personalized help with a DWI arrest in Texas, use the link in the description. Schedule a confidential consultation with my office. We'll analyze your specific situation and build a strategic plan for you. Now, I want to hear from you. Drop your questions in the chat. Some of the best insights come from real world scenarios. And if you're wondering about it, someone else is wondering about it too. So let's talk. Okay, so Little Dirty Birdie says, it's simple. Don't drink and drive. That's it. You should never take a breathalyzer. It always takes a chance. If you haven't been drinking, blood is a lifesaver. This info comes from two Fort Worth PD. Okay, so that's definitely an opinion, right? I don't drink and drive, but the only thing I would say is it's not the only way that you can get into trouble, right? Taking some medicine can get you into trouble. There are plenty of people. Matter of fact, there's something going around the internet in Tennessee. 600 cases were dismissed. 600 DWI cases were dismissed because it came back at zero. Now, let me address a little thing about, when the blood comes out, a lot of people don't want to be pricked by a blood. If you consent to a breath test and you haven't been drinking, it should show up as nothing, right? And as a matter of fact, I have seen a lot of people get a charge because they blow into the machine, it comes back at zero, and then they still take the blood. The blood comes back at zero. So it doesn't really change much on that point. But I take your point. That is definitely one way to do it. You can refuse everything. Now, your license is still going to be suspended if you refuse. All they have to do is say, well, you refuse to do it, then they end up sending it off. When they send it off, DPS gets it. That's why those 15 days are so critical. You must challenge it. You must challenge it, right? Don't wait for the lawyer to challenge it. You can challenge it right away. But it's better if you have the lawyer because the lawyer knows what to put down. I have definitely seen people who have gotten letters and it says, I'm sorry, you messed up. You didn't put all of the information that was required. If you want to, you still have to do it within your 15 days. Except the 15 days pass because it takes forever to get the letter in the first place. So you want to make sure that happens. And no, there's no like, well, hey, I at least asked for it. Shouldn't I get some kind of extra? No, because the point is to suspend your license. Driving is a privilege. It's not a right. So that's why they can do all of those things. Okay? So you got to say the 15 days right away. If you're trying to call this lawyer and that lawyer and that lawyer, right? Or you're just, kind of jumping around, you're like, I don't know, should I call a lawyer? Get on the computer, ask for ALR request Texas. Click on the link, fill out all the information. When you got released, okay, it's in there. All your information is in there. Which police officer pulled you over or performed the test, and what police department they work for. So you want to make sure that that information is in there, and you just submit it, and now we can protect your license. Now you got a little bit extra time. To get a lawyer, and you just tell the lawyer what happened. Now, some of you might be thinking, I'm going to get a lawyer because I don't make no money, or I'm going to get a lawyer appointed for justice. No. That lawyer deals with the crime. You see, a DWI, unlike all other crimes, has two courts you deal with. Court number one is the actual crime. Get arrested for stealing, get arrested for assault, get arrested for criminal trespass, or criminal mischief. None of those things, none of those four things deal at all with any other courts. You just go to the court, you get bond conditions, you're waiting on evidence, you work it out, or you don't, and you go to trial. A DWI, though, you were driving, so your license can get suspended. Let's think about some other ones. Reckless driving, racing. That doesn't suspend your license. You don't have to do anything. So just because you were arrested, nothing happens. But here, DWI is trying to suspend your license to prevent you from driving. So we want to make sure that we are actioning it immediately. I want you guys to keep sending in your questions and follow me for more.